Hello and welcome to this second part of this Field Seymour Parts webinar on IR35 and the changes that are forthcoming. My name is Ian McRae and I'm an employment partner here at the firm, and this is the second part of the webinar where I'm going to be looking at the changes that are coming in April 2020. So without further ado, what are we looking at? Well, from 6th of April 2020, there are going to be changes to how IR35 operates in the private sector. And in very rough terms, that means that for a number of end clients and people in the private sector, the position is now going to mirror the changes that were brought into the public sector in April 2017. The key thing to note though is these changes do not apply and will not apply to small private sector clients. So the key thing will be is to check whether or not the end client, the end user in the relationship falls within these thresholds. So ultimately, an end client company is going to be in scope of these changes if they exceed any two of the following three thresholds. So 10.2 million revenue per annum, having 5.1 million of assets, or having 50 or above employees. The other thing to note is there's some anti-avoidance elements in the regulations. So for group companies, ultimately, if you've got a company and your parent is not a small company, then you're still unfortunately going to be caught. You need to have the end client and indeed the parent company qualifying within that small company threshold, or otherwise these changes will equally be affecting you. So if the end client doesn't fall within these thresholds, then ultimately the position as I've set out in part one of this webinar will still apply. But let's go on to look at the impact on those medium and large organisations which are going to be caught by these changes. So what is going to change? Well, ultimately, the existing position in respect of IR35 is still going to apply. This is not a change to the underlying regulations. But what will shift is that the end users, the end clients at the end of the relationship, those people who are benefiting from the services that are being provided, if their consultants and contractors are using an intermediary, then the end client is going to be responsible for determining whether or not the worker is a deemed employee, for looking at that worker's employment status. And they're going to have to produce a status determination statement. And we'll have a little look about what that involves in a moment. But if they determine that that worker, that contractor does have deemed employment, then they will have to be making payments to HMRC, or potentially, if there's a longer contractual change, they can pass down those obligations to make those deductions to the next company in the chain. But ultimately, this all starts with the end client. Is the end client a medium or large organisation? And if they are the ones that start this process by carrying out this status determination. So in terms of those people who are likely to be affected by these changes, it follows quite naturally from that. So any workers, any individuals that are supplying their services through a personal service company into a client which is going to be a medium or large organisation, so satisfying those thresholds, then they will be affected by these changes. Equally, obviously those medium and large organisations, those MLO clients that engage with workers who use an intermediary, most commonly a personal service company, will again be affected by these changes. And it's important to note that recruitment agencies and other sort of similar sort of middleman operations that again are supplying workers who use an intermediary into one of those MLO, those medium-large organisations, they again will be affected. One key point to note, which is the same as I dealt with in part one, is that this isn't going to change the position that if PAYE is already being deducted, so you've got a recruitment agency that employs its workers and makes the required deductions, or you've maybe got an umbrella company making those deductions, that will still remain outside of scope because essentially the tax is already being accounted for. So that's who's likely to be affected by the changes. Let's have a little look at those requirements on those medium and large organisations. So if you are a medium and large organisation and you've got individuals who are providing services via a personal service company or intermediary, you have an obligation to determine whether or not that worker is a deemed employee. And we've talked about in part 1 those tests that will need to be considered. Once you've considered those, you need to issue a status determination statement. And that has to set out the status that has been determined, so deemed employee or not, and your reasons for it. And there is an obligation within the regulations that you must take reasonable care when determining the status of your workers. That status determination is then sent to the worker, and indeed if there's a middleman agency it should be sent to them as well. And the workers have a right to appeal against that status determination statement. So most commonly, if you've concluded that they are deemed employee and they disagree, then there's a 45-day period in which that sort of appeal process to be dealt with. The key thing to note, if there are failures by the client in respect of this, then they are treated as the fee payer, which will, as we'll see in due course, means that they have responsibility for making those tax and national insurance contribution deductions. Now, it's important to talk about at this point the CEST tool. So this is an online tool provided by HM Revenue and Customs, which is designed to help end clients determine whether or not these workers providing services for an intermediary have deemed employment. Now, the important thing to note is there is no obligation to use it. So if you wish to make your own reasoned and recorded status determination, you can choose to do so. The big advantage of the CEST tool is that the revenue have said they will be bound by the outcomes from it unless essentially you've completed that inaccurately, so you put inaccurate information in it, you've acted fraudulently or something of that nature. However, there are actually a few words of caution with the CEST tool. Firstly, which is the same with any determination, is status can change over time. So what may start as a self-employed relationship could morph into an employed one in due course, so you need to keep it under review. Secondly, the CEST tool has been criticised because it assumes that in every contract there is this idea of mutuality of obligation. Whereas traditionally the decided cases in this area suggest for that there needs to be an obligation to give work and to receive it. The CEST tool does not take that into account in its determination. It has been found to issue what appear to be slightly unusual results, so incorrect determinations, and in 15% of cases, statistically it's been shown that it is indeterminate. So you put in all your information and you don't actually get a definitive answer. Obviously, if you do get that, you would have to go on to make further inquiries or reasoning of your own in terms of why you'd concluded the status one way or the other. So if we've done our status determination as that medium and large organisation and client, we've passed that on to the worker and indeed any agency involved, who then pays those deductions? Who makes those deductions of that income tax and national insurance contributions that are then required? Well, if you have, as we looked at in part 1 of this webinar, the most sort of simple form, the most simple contractual chain, where the end client contracts with an intermediary and then there is the worker after that, then it will have to be that medium or large organisation that has responsibility for making those deductions. If, however, there's a longer contractual chain, so another party involved before we get to the intermediary, like an employment agency, then by making that status determination, the client can shift the obligation for making the deductions to the agency, so shift it down the line. The most important thing to note is that if you are a medium and large organisation, the intermediary now can no longer be responsible for tax and NI deductions. It never shifts that far down the chain. And ultimately, if you are the fee payer, then you need to calculate the taxes that are due, you need to make those required deductions, you need to pay your employer's national insurance contributions, and it all has to be reported through the real-time information HMRC system. So with that in mind, I'll show you what I mean by that slightly longer form of chain. So in part one, we looked at a very simple contractual chain. Here we're sort of adding a further party in. So in our example here, we have our worker who has an intermediary. So for these purposes, we'll assume it's a personal service company, so a company that they control and own. But then they are having a contract not with the end client, but with a third-party agency, and then the agency has the contract with that end client, the client that ultimately benefits from their services, that medium-large organisation. And the importance of adding in that extra agency is it shows how the burden for being the fee payer for making these deductions can shift. So here we have the example where the worker has his intermediary has the contract with the agency has the contract with the client. So the worker performs his services, agency no doubt issues its invoice to the client. Now if the client has made its status determination, and let's assume there is deemed employment, by making that valid status determination and taking reasonable care in doing so, they can shift the burden for making the deductions down to the agency. So the client would just pay its fees as normal, and the agency is then stuck with having to make those required deductions. And the reason it's stuck with it is not allowed to pass it down to the intermediary. And the reason for that is relatively simple. The government has decided that intermediaries cannot be trusted to get that status determination right and to make those required deductions. And that's why it shifts up the chain. So if the agency is stuck with having to make those deductions, then it would have to deduct those sums from the fee that it pays through to the intermediary. And just to be absolutely clear, if there was no agency involved in this scenario, the client has nowhere to shift that fee paying responsibility. It has to shift with that end client. So if you are the fee payer, you have to calculate that deemed direct payment, that is the amount paid to the intermediary, is treated as earnings. You work out the value of that payment to the intermediary, so deducting any VAT. You also have to deduct the direct costs of materials that have or will be used in providing the worker's services. And there are also expenses that can be deducted if they could be treated as taxable earnings if the worker was employed. So if you are a medium-large organisation, what do you need to do now? Well, if anyone's in any doubt as to whether or not you're a medium or large end-user organisation, you need to go away and check those 3 thresholds and see if you're going to fall within them, or maybe your parent company is going to fall within them. But if you are and you're going to be affected by these changes in April, you need to act quite quickly. You need to identify now the individuals that are supplying services into your organisation who use an intermediary, so most commonly a personal service company. You then need to undertake those status determinations, and you can either do that using the CES tool or by your own analysis. But again, remember, you've got to take reasonable care. You've got to record your reasons in writing. You then need to communicate that status determination to the individual and to any agency if there's one involved. And then you need to consider if there needs to be any changes to your existing contracts or the nature of the relationship. So are you happy with the arrangement as it is, or does it need to be renegotiated because of the financial impact of these changes? And you should also think about what you're going to do moving forward. I think it's fair to say that self-employed relationships have not been looked after or considered with probably as much care as employment relationships have in the past. So what you're going to need to make sure is internally you've got a process in place to make sure that as and when new contractors are being taken on, that consideration is given to the nature of that relationship and you've done your required status determination. And then the thing we would say for all businesses, now would be the time to make sure those terms and conditions are in good condition and are matching the type of relationship that you are trying to put in place. So a few final points. All of this comes with the normal caveat. This is obviously only a very brief introductory guide. You should always take independent legal advice on your own circumstances. We will be updating on this area of law as things develop, and if you'd like to receive those free email updates, then please do contact me on the details on the slide. And also, please do consider watching, if you haven't already, part 1 of this webinar, which talks about the current status before the changes in April, and also part 3, where we're going to be talking in more detail about those contractual issues.